NACDL is the association of the nation's criminal defense bar.
Let's turn over to our esteemed panel that we have to start off day 2 of the conference, which is going to be focusing on reversing the tide on geofence and keyword warrants. So with that, I'm really excited to introduce our moderator for this panel because he comes in-house here at NACDL. You heard from one of his colleagues yesterday, Jemana Musa, in our pretextual policing panel. So Michael Price serves as the litigation director for NACDL's Fourth Amendment Center. And I'm going to turn over to him to further introduce our panel.
Thank you so much, Monica, and great to be with you all. I am very happy to have this opportunity to talk with everybody today. I'm Mike Price. I'm the litigation director for NACDL's Fourth Amendment Center. I'll be your moderator and also a panelist for today's talk. I hope you'll bear with me on that. But the Fourth Amendment Center provides resources and trainings on issues involving privacy and new technologies, including the things we're going to talk about today. We also provide litigation assistance. So if you're a defense lawyer and you have one of these issues in your case, please contact us. You don't have to be an NACDL member to get assistance, but you should still join. It's a fantastic organization. Today, we're going to talk about reverse warrants, a new and highly invasive type of digital surveillance. We're going to start with explaining what they are, and then talk about what's wrong with them, and then what we can do about them. So I would really like to thank Monica Reed, Shirley Carroll, Kate Holden, Jemana Musa, and Kyle Odad for making this discussion possible. And of course, I'd like to begin by introducing our two other esteemed panelists, Laura Koenig and Hayley Tsukayama. Laura Koenig is an assistant federal defender in the Richmond office for the Eastern District of Virginia. She provides zealous client-centered representation in a wide variety of district court and appellate cases. Laura previously clerked for federal district court judges in Indianapolis, Indiana, Atlanta, and Georgia, and was lucky enough to have spent several years in the fearless Colorado State Public Defender System. Laura is also co-counsel with me on the leading challenge to Geofence warrants, USB shot rate.
Glad to be here. Thank you.
Thank you so much, Laura. And Hayley Tsukayama is a senior legislative activist at the Electronic Frontier Foundation, EFF, focusing on state legislation. And prior to joining EFF, she spent 8 years as a consumer technology reporter at the Washington Post, which is really cool. Has an MA in journalism from the University of Missouri and a BA in history from Vassar. And I think most relevant here, Hayley has been one of the driving forces behind the push to ban reverse warrants in California. So I guess, first things first, what is a reverse warrant? And I'm going to set the stage a little bit and say, think of a normal warrant. Think of a normal warrant identifying a suspect, establishing probable cause to search their data. And then imagine that process in reverse. The police don't have a suspect. They don't have probable cause to search anyone in particular. So they get a warrant to search everyone's data and come up with the suspect later. that is the essence of a reverse warrant, or as I say, at least for our purposes, what happens when Google searches for you. There are a couple of types of reverse warrants that we're going to talk about today, geofence and keyword warrants. And we're going to mostly be talking about Google because Google has been the recipient of most of these warrants. And that's where police have been turning to get this data. Google, a few years ago, released some data on how many geofence warrants they were getting. And what was clear over the course of 2018 to 2020 was that they were getting more and more common. It was going from a couple of hundred to a few thousand. And as we're starting to see now, this tide is starting to come in. So Google now is reporting that more than a quarter of the 40,000 search warrants it gets every year are now reverse warrants. So that's 10,000 a year. It's a fourfold increase since 2018. And we're going to try and take a look today at why this is so troubling, ongoing efforts to sort of reverse this tide on geofence warrants and keyword warrants, and then take some questions from the chat at the end. Please put those in the Q&A. So I guess with that, I'd love to bounce it over to Laura and just ask you to tell us what's a geofence warrant. What are we talking about here?
Sure. So like Mike was saying, this is what happens in these reverse warrants, and a geofence warrant specifically, is the police do not know. Some crime has happened. They do not have a suspect. And they're thinking, how are we going to go about getting a suspect here? And so they started by thinking, well, Google collects all this data and we would love to get in there. So with a geofence warrant, the police go to Google and they ask Google to turn over all of the information, all the location history information on the devices that are supposed to be somewhere near the scene of this crime. And so Google then goes to its database that it created and somewhat ominously called the sensor vault. And it contains the location history data for each account that has this location tracking, this service enabled. And what ends up happening is it's this huge dragnet that requires Google to search hundreds of millions of accounts for each warrant in order to produce this information. And what we found, right, is that they do not have probable cause for any of it, let alone some of it. And so we want to start first by talking about what is location history. So I will say the first time I saw one of these warrants, I was like, what is this? Like, what is happening here? I'm running down the hallways of my office saying, have you guys seen this? What's happening? And so we started sending out like cries for help. And that's how I was introduced to Mike. And Mike, of course, had been thinking about this for a while and was talking with me about it. And one of the first things that I did was go to my phone and say, do I have location history enabled? So we want to do that with you guys. If you have an Android phone, if you go onto your Maps app, and then if you click on the little hamburger symbol that has the three little lines on the top left corner, there's an option to say your timeline. And if you click on the your timeline part, if you see data there, then your location history is on. Your information is going to Google and is being searched in each and every one of these warrants. And if you have an iPhone, then you're going to go to Google Maps if you have it. If you don't, great for you. But if you have it, you're going to go to Google Maps. You're going to, again, click on the hamburger and you're going to select your timeline. And again, if there's data in there, then you've got that location history enabled, which puts you in the Sensor Vault lottery. And so we want to talk about, like, how is it that Google collects this information? It's important to know how it works, because this is not exactly like other kinds of cell phone location data that you might have seen before. It doesn't work like cell site location information, for example. I think of it more of like a surveillance smorgasbord. So Google uses multiple sources of data. They use GPS, so satellite data. They use Wi-Fi and Bluetooth, cell towers, and also IP addresses. So when you're looking on your map and there's that little blue dot with the little circle around it, that is what Google is guessing is your approximate location based on the various inputs of this surveillance smorgasbord, and then using it, plugging it into its proprietary algorithm. So it used to be like, if some of us are a little older than others in this conversation, and you may remember Google was like driving around cars and it had a little camera mounted on the top, and it was doing this street view collection. But now they're using phones to report Wi-Fi networks that they just see along with a kind of like triangulation with coordinates, GPS coordinates when it sees them. So what that means is, you go home, you're at your office and you're connected to a Wi-Fi device. You think, oh, okay, I'm connected. Maybe that's what they're collecting. That is not the only thing that they're collecting. They're also collecting when you are just walking down the street and your phone happens to pick up a signal from some other Wi-Fi at the coffee shop or the bank or your neighbor's house or anything else that's around. If your phone has seen that Wi-Fi network, that information is being transmitted back to Google, and they're using it to track where devices are at all times. And importantly, this is just an estimate. So Google creates this, right? Because they're trying to sell ads. They just want to get ads together. So it's like, it doesn't really matter if you're that close to the McDonald's that they're trying to send you an ad to, but you're close enough. So this is an approximate estimation of the location. That's what they created this for. So when we're talking about a geofence, what we've typically seen is the government follow a 3-step process. And so what we're looking at right now is a couple of different kinds of examples. You're flipping through your discovery, you see something like this, your immediate reaction needs to be, I remember that presentation, they're talking about a geofence. So the police draw some shape. It can be a square, a trapezoid, a circle, anything that has closed boundaries. And they identify it by saying longitude and latitudes. And then they're also going to identify in the warrant a window of time. So maybe it's 20 minutes, maybe it's 2 hours, maybe it's more than that. And they're going to tell Google with the warrant to give over the data that Google has for any device that's inside the geofence during that time. And we'll talk about what does it mean to be inside the warrant. But the very first thing that Google has to do in this 3-step process is when Google gets one of these warrants, they have to search each and every account that has location history enabled. And that's because of how Google stores the information. They don't have a pile of data. Like I live in Virginia, I'm in Virginia right now. They don't have a pile that says Richmond, Virginia, let's sift through all that. It's stored. This information is stored by user account. As we all know, we move around, right? So it's not seemingly possible for them to store it by location. And so they store it by user account. So in order to find locations, they have to search through every single user account in the entire state, the neighborhood, the United States, throughout North America, everywhere in the entire Western Hemisphere, all over the globe. Anybody who has location history enabled is going to get searched. And afterwards, Google purports to provide anonymized data for the devices inside the geofence. And they say that it's anonymized because they attach like a number, like a random number that doesn't say Laura Koenig is attached to this information. But what we have seen is that information, that number, can remain the same from warrant to warrant to warrant. And you also don't necessarily need a lot of information to figure out who people are. So it's not anonymized. We don't want you to come away thinking, oh, it's anonymous, because that's one of the tricks. Like that's one of the tricks that are happening here, the sleights of hand. So when we're talking about like how many people, like what does this mean? Like how many people are actually being searched? So in the Chatri case that Mike and I have worked on together, what Google told us in the litigation in that case was it's numerous tens of millions of Google users. And despite a fair amount of pushing, they wouldn't get more specific than that. And that was in 2019. So Mike is working on a different case, or has worked on a different case, in which they got Google to disclose that at least in 2018, it was 592 million people around the world that had location history enabled. One would presume 5 years later, we probably have more than that now. So going back to the three-step process, is that step one is they search everybody, all 192 million plus whatever increases we have since then. Step number two is that they give over this anonymized data to the police, and the police sort through it, and they think they're going to find devices of interest, which means they're going to be able to track and see where these devices go within that time frame. And if the device goes to my house or goes to my work, it doesn't take too many points of data to figure out who these people are. And so even though it's purported to be anonymized, sometimes even at this first stage, sometimes it's possible for the police to be able to have a decent idea about who may be tracked. And then step two, that's step one. Once you get to step two, they take the time frame off. Sometimes they take the geographic limit off, but the limits are changed between that first step and the second step. And so you get a longer span of time, so you're able to track people more distance for a longer period of time. You're going to get that more personalized, granular information. And then in step three, this is where Google pulls back the curtain and says, okay, here's who this person is, even if they might have a good idea about who they are already. These are like sort of the finalists, so to speak, in like a really bad reality TV show. And what Google will turn over in that third step is the name of the person or other subscriber information that can include very, very personal information, such as numbers, email addresses, things that are unique to the individual. So we've seen that these steps can vary. Sometimes warrants have just one or two steps. Sometimes we see multiple geofences at stage one. But we usually see the three-step process, and that is where we're going to turn it over to Mike to talk about keyword warrants now, and we'll come back to talk about what's wrong with these later.
Thank you so much, Laura. I know that's a lot. I will spare you a little bit on keyword warrants, because they are similar in some ways, although also maybe a little scarier. A keyword warrant is like a geofence warrant, except they're not looking for location information. What they're looking for are anybody who has searched for a certain term or a set of terms over a period of time. It could be an address, like the scene of the crime, a name, the victim's name, or more general things entirely, like the name of a group or things like cardboard. If you get one of these, it's going to be directed to Google. If you see one of these, it's going to be directed to Google, and there's going to be a list of search terms. Not just one, but sort of variations on the theme. This is variations on the theme of an address from the Seymour case out of Colorado. But it could be any terms. I wasn't joking about cardboard. Here it is. Also the term package out of the Southern District of Texas, right? This is in response to a pipe bomb case, but the terms that they are using here are extraordinarily common. When the government executes a keyword warrant, just like a geofence warrant, it has to search everybody for which it has data. And Google has testified that it searches not just people who are signed in, who are authenticated in Google's parlance, but both. Anybody who is using Google services. And that means that they are searching people who are not signed in, not authenticated. And Google draws this distinction in the way that it provides the data. If you are signed in when you do a Google search, it will be linked to something called your Gaia ID, your Google Accounts and Administration ID. And that means stored in your user account. It can be, you can delete it manually, automatically. It is your data stored in your account. And if you're not authenticated, still your data, but it's associated with something that Google generates every time you visit their website called a browser cookie ID. It's basically a unique number that Google assigns to your computer browser. You can't delete it. It's not clear how long Google stores them for. But the sort of upshot of that is that whereas with the geofence, you had to be opted into location history to get selected into the wrongful arrest lottery, with a keyword warrant, you're automatically enrolled anytime you do one of those keyword searches. So the question then becomes, Google has to search, well, 592 million people for a geofence warrant. What about a keyword warrant? They're searching everybody now, not just those folks that have location history enabled. So how many is it? And the answer is we're talking about billions, not just one or two either. And according to Google, there are more than 1 billion average monthly users of Google search, up to 8 billion if you combine the anonymous searches every day. And Google searches both Google search, so like the search engine, but also anything you put into Google Maps. So it's the same essential search engine. And anything you type into Maps is also going to register with your search history. There's no real opt-in or opt-out on that front. So we're talking about billions of authenticated users plus billions more of unauthenticated users. So a keyword search, I guess, depending on the time frame, is it a day or a week or a month? Maybe many multiples as broad as a geofence warrant in any case. This is what a keyword warrant return looks like. Google provides it in this format to police, a database format like Excel called a CSV file. And it's going to include everything from the date and time of the search to the nature of the search and the information requested and produced and how it was requested. And you can see this throughout these returns. It doesn't matter where in the world, the city, the country, the state, the world you are, there is no geographic limit. Even if the crime occurred in one state, you're often going to see similar searches from other states. Main Street is a common street, right? And it turns out that lots of addresses have things in common. Plus, the fact that the query is going to necessarily contain additional words. Google's going to attempt to suggest phrases like it would for you otherwise, or include things otherwise that are outside the scope of that warrant. And whatever the government says about these things being anonymized, if they are providing the full IP address, like they do in this instance, then it's not anonymous. Your IP address is traceable back to you in all but the most extreme circumstances. And so if Google is logging the IP address, even if you're not logged into your account, chances are there is some record linking it back to your account. I want to ask Hayley now to sort of weigh in. Laura and I have described the two types of reverse warrants, geofence and keyword. Why, Hayley, should we be concerned about these things from a privacy perspective and maybe other perspectives?
Yeah, so happy to talk about that. You know, I think you all have just learned a lot about how these things work. You know, when it's maybe apparent to you, but these are a couple of points that we bring, for example, to legislators when we're trying to talk to them about sort of why we're so concerned about these. So, you know, as Mike said, reverse demands turn the normal person's idea of due process on its head, right? Like if I think about what I learned in 9th grade civics about how warrants work, it's completely backwards, right? As Chad Marlowe at the ACLU says, rather than, you know, hey, help us find this needle in a haystack, these are really demands that say, give us a haystack. And whether the needle is in there or not, we'll figure it out, like, don't worry about it. And of course, we all leave a digital trail, and you know, really having that subject to being rifled through is on its face like just a pretty scary and concerning privacy violation, particularly with the information we're talking about here, right? Where we go and what we search reveals a lot about who we are. You know, a geofence can reveal who's dropping their kids off at what school, what religious institution they might go to, what organizations they're associated with, who they might be near, right? Who they might be associated with. And really by simply being in a particular place as a part of your daily life, you know, a lot of people have their privacy invaded for no reason at all. When we were working on legislative advocacy around geofence and keyword warrants, you know, we were often asked, like, can you give us an example? And our lawyers said, well, in the Mesa case in California, there was one warrant issued in Los Angeles County, for example, asked for the information of everyone within the equivalent of 24 football fields for several hours during a Friday morning commute. You just think about all the cars that are there, who could be going back and forth, right? You could be seeing multiple exits that people are going through. You think about the population density of somewhere like LA County, right? Even if it's just one building, if it's a building with a bunch of people and if it's a dense apartment building, that's a lot of people. So really just the breadth that we're talking about is really staggering. And I think that's landed. And keyword searches, you know, they're also obviously very broad. You know, in legislatures, we've had people ask about, well, okay, what if we just limited keyword warrants to everyone who searched for how to poison or how to dispose of a body or something like that. And then I was thinking back, you know, I have a background as a journalist, and I have Googled some heinous things in the course of reporting, for example, that could be seen as really incriminating. Essentially, you know, in my more unguarded moments when I'm talking to legislators, it's essentially thought crime, right? It's sort of like whatever you can put into a search really can put you at risk. And you may think, okay, well, I've never been anywhere I shouldn't, or I've never Googled anything I shouldn't, which, you know, I question, but, you know, but these warrants have been used for fishing expeditions. They've already been used to track the locations and identities of people, for example, protesting police violence. That's a protected right. So, you know, reverse demands can also chill the exercise of freedom of speech, association, religion, assembly, movement, and the press, which is just a lot of activities.
I mean, I would love for you to just expand on that a little bit, because we were talking about Fourth Amendment issues and privacy rights. But when we start talking about keyword warrants, especially, it seems like we're getting into First Amendment territory, right? What information am I allowed to have? And I wonder if you can speak to that a little bit in terms of the First Amendment concerns that are present, in addition to whatever privacy concerns we might have.
Yeah, I mean, I think certainly, yeah, I mean, sorry, I'm just again thinking back to when I was a journalist and I was Googling things. I mean, if I was really nervous about somebody, you know, serving a warrant around, you know, if I was covering a case, for example, and or covering a crime, and I was worried about, you know, I was kind of Googling information about, you know, a particular address or something, like, you know, it would, I think, make me think twice about sort of what I put in. So it's not even just policing what may already be in my Google account. It's also policing what I may want to keep out of my Google account, and just trying to figure out what that means. And that it's such a ubiquitous tool. It really is hampering. It could hamper a lot of what people are trying to do.
Yeah, I feel like, tell me if you agree, that most of the time when we talk about freedom of speech, people think about, well, what can I say? How big can my microphone be? But the question is not as often, what am I allowed to hear? And what information can I have access to? And the two seem to me to be very flip sides of the same coin. What good is speech if I can't listen to it?
Yeah, I totally agree.
How do you, do you think that the keyword warrants have an impact on that sort of First Amendment activity?
Yeah, I certainly think, I'll go into this a little bit later, but, one reason that we are worried about, newly worried, continue to be worried about some of these warrants is, if you're looking at, for example, the criminalization of reproductive care or the criminalization of gender affirming care in a lot of states, some of those bills and those laws are written very broadly. And I worry about, sort of, if you are in a position where you are, particularly if you are a young person, for example, who maybe your family wouldn't support your lifestyle or your decision, that, really Google is probably the first place you're going to turn. And so I become very concerned about, sort of what kind of, as you say, access people can have to reliable information. And in the states that, we're seeing the criminalization of those sorts of, that sort of healthcare, we're also seeing a crackdown on sort of what information can be given or displayed to young people. So that is like a particular instance in which I'm especially worried about these kinds of warrants, really chilling access to information.
No, it's an incredible related point, and especially given the news about the circuit court's decision yesterday, there might be some question about what searching for mifepristone really means, and whether that might be interpreted as horrible as it sounds, evidence of criminal intent, right? So thank you for explaining those consequences. I want to shift gears a little bit for us and talk about some of the things that are being done to push back on reverse warrants. So it's not like we're just sitting here talking about them. They're being challenged in court. They're being challenged, and there are pushbacks legislatively. And I want to get into those. Laura, I think this is for you to talk about what challenges geofence warrants have faced in court, obviously including the Chaudhry case, and how courts have responded to them.
Sure. Just a few quick things that we can probably check off in the questions list. So geofence warrants do address the historical location data. So that just a kind of like a technology point to get out of the way. But one of the things that we have to, like in a legal challenge, the way that this has typically been structured is Google wants to see a warrant, right? They're not just responding necessarily to simply just subpoenas. So we kind of we miss that first part of sometimes in our own initial thought process of the things that we need to think about in order to succeed on a challenge. So first is establishing that we have a reasonable expectation of privacy in our location history. And I know Mike will talk about that with keyword warrants, I assume later. And then we have to argue that the warrant was invalid if they got a warrant. And then if that arises that there is no good faith. So the first part can seem kind of odd because Google typically requires these warrants. But oftentimes the government is asserting that they don't need to seek a warrant because of this thing called the third party doctrine, which is something that was created a long time ago in a different kind of era that we have now in terms of technology. But the argument is because we're voluntarily conveying this information to Google, then it shouldn't apply. So we're going to point you to some like ways that you can find answers to that, because we've been litigating this for a long time. And we'll show you that in just a moment, I think. But one of the things that you also want to think about in addition to the third party doctrine response is thinking about that we still have some people in the judiciary, some justices on the Supreme Court, who think about things through a property law lens. So you want to also make that argument too, because then it prevents the need to even get into the third party doctrine, if that's what the basis of the holding is. So that only gets you to the warrant, right? You get the warrant, and then you got to say that the warrant is invalid. And so the typical ways to think about this is that the warrant is so overbroad. It's a classic dragnet search that ropes in at the first stage, 592 million people at a bare minimum. And it puts all kinds of people who use a Google service at any time. Like, we know that this data is being collected on a constant basis. It's overbroad. It doesn't have particularity, because we know that there's no way that the cops have particularity to search 592 billion people in the first stage, let alone however many people are sort of innocently captured in the second stage. They just don't have that. So then you get to what should be the easy part, right? The good faith part, the good faith. Everybody hopefully is listening and thinking, this sounds so awful. Why should this even be a question about good faith? But you have to argue it. You have to figure out how it is that you're going to convince your judge that nobody should be signing off on these warrants at all. The police should have known better. Maybe they did know better, and they went ahead and got the warrant anyway. Because this is essentially like getting a warrant to search every haystack, or every haystack in the entire world, every house in the country. No officer would ever think that this warrant should be valid. So just if we could just focus on like the overbreadth for just a minute, like, because that's the piece, that's like the main piece here, right? So it requires searching all of the accounts that have the location history enabled. And at least in some litigation, Google has told us it's about 1/3 of the Google users, and in other litigation, 592 million people. And so we know that this is hundreds of millions of people each time, like in that graph that Mike showed at the beginning that keeps going up and up and up about how many reverse warrants they're getting. It's hundreds of millions of people that are searched in every single one of these warrants, and no judge should ever sign off on that. So you got to make sure that we're telling this to them as we're working through this. And so the flip side of the overbreadth, right, is the lack of particularity. And one of the pieces of this that is so important with geofence warrants is the amount of discretion that is given to the police. The law says police should not have discretion. They should get this warrant. They should go execute it. It should be clear, crystal clear. But that's not what happens here. In the first step, in many of these warrants we've seen, they get the warrant, they serve it on Google, Google sends back some data, and the government doesn't go back, the police don't go back to Google and say, oh, well, or to the judge and say, can we get another warrant to see if we can search more information about these other folks? No, they just go back to Google and say, oh, we'd like information on Sally Q number 5, right? Like, and they get that information. And then instead of going back to the judge and saying, well, we really think it's now these 3 or 4 people that we're really interested in, or however many people they put in the finalist list in stage 3, they don't go back to the judge and get a third warrant. They just go back to Google and say, well, now, sir, we would like to have all the subscriber information you could possibly muster up to give us at stage 3. And that's a real problem, right? Like, that just can't happen. Like, that is not something that our Constitution allows. So, that's, I think, the main things. But Mike and I, we wanted to bring to your attention, like the Chatri case, because that is where we have spent a lot of time digging into the evidence of this and figuring out how these things work. What are the problems that exist? And so in the Chatri case at the district court level, the district court found that the geofence warrant violated the 4th Amendment because it wasn't particularized and it was overbroad. And so these are just some of the kind of main quotes that came from that opinion. But another thing to think about is that we still have a lot of room left to learn, right? Like we don't want to just think, oh, we have one opinion, we have some information. We want to keep challenging these and keep figuring out how this is going to work, because as Mike is saying, like they're going to keep shifting, right? They're going to shift the game, shift the name of how they're calling it. And so we do have, in addition to Chatri, we have several geofence opinions around the country. A lot of them predate the opinion, the district court opinion in Chatri. And many of them, the district court in Chatri relied on because these were magistrates who most of the time on their own were just getting these Google warrants and thinking, this is not right. We need to find out some more information here, or we're not going to let this happen. And so on the screen right now are some of these opinions. I wouldn't stress about writing them down because I think we are going to make these available. But most of these courts have found that the geofence warrants are unconstitutional. I'm going to flip it back to Mike to talk about one that is still kind of an outlier.
No, they all have such catchy names. I don't know how you could possibly not remember every single one of them. I mean, I think it is interesting to note, like a lot of these cases are happening. They look this way because they didn't make it to trial. There is no US versus somebody, because these were cases where judges looked at what was happening in Chatri and said, you're applying for a warrant? Is it like that one? Oh, no, I'm going to take a closer look. And it wasn't until this information sort of got out there that judges started to look at it and say, hang on a second. So, you know, I think that is encouraging, and especially here, you know, we're seeing a large number of these courts saying, no, it's not okay. They have different reasons for why it's not okay, but you know, that is a promising response, at least even when there isn't defense counsel on the other side, in terms of saying, hey, this is really offensive to our sense of you know, democracy and fairness to search everybody, and we're just not going to go with it. That said, there have been courts that have found that geofence warrants are a-okay, and one of those famously comes out of the January 6th prosecutions. It's a case called US v. Rhine is probably the most prominent example of a court upholding a geofence warrant. But I think, as you'll see, it also followed a completely different process from like the Chatri case and basically any other geofence warrant you'll see. They drew the geofence warrant directly over the Capitol building, as anybody who was in there was either supposed to be there or very much not supposed to be there. They did their best to not include areas outside of it. They also did a number of control geofences both before and after the riots to see who in their mind was supposed to be there and who wasn't supposed to be there. And they also did this weird thing where they turned over sort of an additional list of people who they thought were there based on folks who had deleted their location history during that time. And found like an additional 70 people that way. The court in Chatri sort of anticipated this case explicitly on a footnote, and the court did go to great lengths to distinguish it from the Chatri case, which is obviously, you know, very different on its facts. There are a couple of other significant differences to note here, that there, you know, these were devices that had at least one data point falling with inside, but may have had data points falling outside of the Capitol. And the court was required in between steps 2 and 3 to approve the list of people who would have additional data search. So that was a step in going back to the court that didn't occur in other cases. I do not believe that absolves it constitutionally. I think none of this gets past the fact that you have to search everybody to begin with, even if you're more careful about what data you use afterwards, or, you know, theoretically careful. But this is the way things have played out in at least the high profile cases that we have here. And Ryan is distinguishable from Chaudhry for a number of reasons, but you know, there was no finding of expectation of privacy here. The court just sort of skipped over that part. The court also ignored the fact that you still have to search the whole haystack, even if you very precisely define the needle you're looking for. It does not change the fact that you are still searching 592 hundreds of millions of people in order to identify folks in the geofence. And obviously we have a distinction here in terms of steps 2 and 3. So the case, geofence warrants in general have changed over time. I think it's significant to note. The Chaudhry warrant was one of the first ones to be challenged, but they have changed since then, and may include these extra steps that complicate the factual analysis. Still, I think the principles remain the same, but that is where we are in terms of the litigation on these things. The Supreme Court has not weighed in, and we don't have any appellate court decisions on geofence warrants as of yet. I want to, I guess, moderator, panelist privilege, move on to keyword warrants. I give a little bit of an overview of what they are and how to challenge them. The idea behind a keyword warrant is very much like a geofence warrant. You still need to show it was a search to challenge it, that there was a privacy interest in what you searched for, that it's either your data or you have a privacy interest in it. You're still going to need to show that it was unconstitutionally broad and lacking particularity. The bonus here is with First Amendment concerns, and as Laura was discussing earlier, there's the hurdle of good faith, which is to say, even if we all agree that it's unconstitutional, does the government save itself by having at least gotten a warrant? And you know, to reiterate, I think we're saying it's not a real warrant. This is no warrant works like this. But to challenge one of these things, the very first thing you got to do as a defense lawyer is establish a Fourth Amendment interest, an expectation of privacy in this data. And it's odd because the government kind of stands on its head to say, well, you don't. You're typing this stuff into a search bar and sending it off to a giant multinational company that might provide you some helpful information. But you know, how can you say that that's private? And our argument here is that this data is some of the most private data that could possibly exist. If we're talking about what you look up at a library or read in the privacy of your home, that is the quintessential type of First Amendment activity that the framers were trying to protect. And this is coming out of a case in largely being litigated out of case in Colorado right now, which is before the Colorado Supreme Court. And there is not just a question of whether you have a Fourth Amendment interest in this information, but whether there is a First Amendment interest in protecting it, which the Electronic Frontier Foundation talked at length about in an amicus brief, and I'll let Hayley speak about it separately. But we're just arguing, in addition, this is your data. What you do online is yours. The Google is storing it in your account. Yes, you sign an agreement and they may be able to sell advertising based off of some version of that information, but it is not the same as turning it all over to the government. And that you lose an expectation of privacy just because you are Googling something or searching something online. If that was the rule, then anything you do online, for the most part, would not be private because it's almost necessarily going to involve some other person or company in the middle. But that this information is yours, and yours to delete, save, use as you see fit, just like your emails, your text messages, your photos, your documents that might be saved in your cloud account. So there's a Fourth Amendment interest in it. Do they get to search it? Well, do they have probable cause for everybody that they're going to search? No, they don't. In fact, they have no idea who they want to search. That's why they're doing this. So they don't have probable cause for even one person, let alone hundreds of millions or billions of people at a time. Nor do they have probable cause to search for all the ancillary terms or variations on terms that Google may helpfully try and produce. So what about particularity? Where are we going to search? Well, the government says we're very particular. We know where Google's address is. We looked it up online. It said, we Googled it even. It's 1600 Amphitheater Parkway. We can just put that in our affidavit. That's where we're going to search. What's wrong with that? Well, that is where everybody in the world houses their data, right? It would be the equivalent of searching an apartment building that was 1 billion stories tall, and just saying, hey, can we just peek inside at your papers? We want to see if you looked for this thing. If not, don't worry, you got nothing to hide. We're just going to check out everybody in this big apartment building that happens to house almost everyone in the world, right? They are not identifying individual accounts. They're identifying the place where everybody stores their stuff, but not saying who they're looking for or which account they might search. So this is the digital equivalent of a general warrant, of going into an apartment building and saying, we think the thief is hiding out somewhere in there, so we're just going to search everything real quick, and we'll let you know if we find it. So again, this violates sort of basic Fourth Amendment principles and is what we're challenging. We're challenging it legally, right, in individual criminal cases, and we are very much waiting for decisions to come out at appellate court levels to set principles guiding police and shaping the landscape going forward. Unfortunately, we're still waiting on many of those to come out, and are stuck at the moment until they progress, except for the wonderful work that our colleagues and advocates are doing at EFF and ACLU and around the country, and pushing legislation to preempt this. And I think it's so incredibly important because it has the potential to short circuit that dynamic of tech getting out ahead of the law if we don't have to wait for all these things to percolate up to the Supreme Court. And Hayley, I would love it if you can speak for a bit about the different legislative efforts that are going on around the country to try and challenge these things.
Yeah, definitely. And I should say, you know, from the appreciation goes both ways, right? When we're showing up in legislators' offices and we're saying this is a problem, they're like, well, show me how it's a problem. And we can point to these cases and these decisions and be like, look, you know, it's not just us as privacy advocates saying that this is a problem. There, you know, there is case law. So it's definitely a hand-in-hand approach. So I'm happy to talk about a few of the bills that we've seen. So California is the one that I've been most involved with. You can see that EFF has a very distinctive art style, and that is our little bug to show people about our bill. So this bill, AB 793, was introduced as a ban on all geofence and keyword warrants. It included, demands, so warrants as well as sort of the voluntary requests when companies are turning over information, you know, without a warrant, or also we also wanted to get at, for example, police databases sharing across state lines in particular. It included a suppression remedy. It included a right for individuals to sue if their rights were violated at PRA. So we really swung for the fences at introduction. As with that strong bill, we gained support from more than 50 groups. In our strategy in the California legislature was really, as I sort of hinted at earlier, to talk about the dangers that we were worried about when it comes to folks who are seeking reproductive or gender affirming care, particularly those coming from outside California to into California to seek that care, or who are looking for that care in California. So some sort of nexus to the state. And so we were able to build, we co-sponsored that bill with ACLU of Northern California, or I guess ACLU California Action, and If When How, which is a great legal reproductive organization. And had support from more than 50 groups, as well as Google was also a supporter of that bill. They are very, I think they would like to see clearer rules around what they should be doing when they get these. And, you know, I think they feel Google doesn't always have the best privacy reputation, but I think they do genuinely feel they're between a rock and a hard place on this one. You know, California has pretty strong, well, relatively strong consumer data privacy laws, but when you're talking about turning over information for an investigation or to law enforcement, there are always a lot of exceptions to those kinds of laws. So we gained support from all these groups. We had a great coalition. We did face strong opposition, particularly from the sheriffs in California, as well as the DAs. And so our bill did pass the assembly in its strongest form, but we did have to make a commitment to focus it specifically on reproductive and gender affirming care. So we are currently trying to work through how to write that bill in a way that is both protective of kind of the things that we're concerned about and doesn't in any way kind of validate warrants that are not in that particular focus. I think you know, what we're really thinking is we want to offer the fastest protections we can for this sort of emerging threat that we see around reproductive and gender affirming care. You know, in the last database or the last data dump that Google gave us on reverse warrants, 5,700 of the warrants that were issued from states that now criminalize that kind of care. So even though we haven't necessarily seen an example of these warrants being used in this context, if past is prologue, I feel like we're going to see it coming. And so we are just trying to figure out how to provide the best protection for the people who need it most right now, and then try and use that as a way to build out. So that's where California stands. And if you want, I can talk about some of the other ones.
Yeah. A quick follow-up on that, because I do see this dynamic playing out in other places where there's a particular focus on reproductive rights and privacy right now in the post-Dobbs era. and a desire to protect people searching or seeking that sort of care. But the concern is among some defense lawyers, if we legitimize it, does that legitimize it for other uses? If it's protected for reproductive rights purposes only, does it legitimize it in other contexts, and how do we prevent that from happening?
Yeah, I mean, it's honestly, it's why we're taking the time to really try and think about how to write this before it gets reintroduced in January. I mean, it's a thing I worry about with a lot of privacy law in general, right? Often it's unfortunately a political calculation. You make more than a policy calculation. So, you'll see, oh, we'll protect location data, but only, or we'll protect data, but only location data in a slice, or only health data in a slice, or something like that. So often, unfortunately, with advocacy, it's often you're trying to figure out, okay, what parts of the loaf can I slice off and say, I reserve the right to come back to that later. And so I wish I had like a good answer of how we're going to do that. That's definitely the thing that we are talking about right now, because I think, well, certainly EFF believes in its heart of hearts that these just shouldn't be a thing, right? That these are just unconstitutional, and so we're trying to figure out how we message that, and that's like a lot of my job in the coalition, is trying to figure out the messaging around how we say, okay, we're doing this, but not because we're okay with everything else. So it's a tricky road to walk.
It's definitely a curveball. Are there a couple of other examples you might be able to speak to?
Yeah, so New York has also introduced, so a few actually. So New York introduced a bill that also bans both geofence and keyword warrants. It also bans police purchases of similar data from tech companies and data brokers. So you can see they've taken a slightly different approach right there. It's a broader approach, and they're trying to get at sort of a lot of ways that police get similar kinds of information. I actually realized I put in, so New York was the first state to introduce this sort of warrant or ban, as far as I know. And so this is actually the first bill. Currently, it's Senate Bill 217 and Assembly Bill A3306. So if folks are looking to track those. So that is New York. Missouri has also introduced a bill. Sorry, I'm just kind of blitzing through, but Missouri has also introduced a bill. I think it's interesting to point out that they use very different framing in Missouri, right? They really looked at more of the sort of First Amendment concerns that we were talking about, sort of saying, investigations of search queries raise concerns similar to like investigations of records held by bookstores and libraries, that sort of thing. They focused a lot on protests, and particularly interesting there, I think, we often see quite progressive authors pick up these bills, but in Missouri it was a Republican author, and I think that shows both that they're I always say, like, privacy and speech issues are bipartisan. And so I think that demonstrates that. And then also, I think just interesting to show the many ways you can frame this issue. It's such a big one. And so I think that's interesting. And then in terms of other bills, there was a sort of guideline model that Utah passed earlier this year. It actually passed unanimously through that legislature, which is quite a conservative legislature. They're putting guidelines on specifically reverse location searches. It is not a ban. It's not really it. They were trying to get at some of those voluntary requests. So they say they require a warrant for geofence demands. They also require a warrant for cell site simulator demands. So again, kind of see how they're packaging things a little differently. Requires a transparency report be issued, and requires a notice to people who are included in a warrant, although that notice sunsets in January 2033. So overall, I would say this is a much more lenient bill kind of addressing this issue. It's, you know, in my personal opinion, I would really rather see the kind of stronger bans go through, but that is something that states have considered. Not my favorite model, I have to admit. And then other states are looking at location data in different ways. So Massachusetts has what they're calling the Location Shield Act, also kind of centered around, well, I mean, it's general location data, but also talking a lot about the repro and gender affirming care threat. That would stop the sale of location data. So not necessarily completely on topic for here, but, you know, sort of looking a lot of awareness, I guess, raised about location data in general across state legislatures, and I expect to see more of that. And I believe Delaware also has an early bill. So we are seeing more of these bills pop up across the country. I think a lot more attention is being paid to this. I would give a lot of credit over to ACLU and Chad Marlowe at the ACLU for raising a lot of that, and a lot of state chapters at ACLU are really behind the driving force behind a lot of these bills.
Thank you so much, Hayley. I think you actually answered with the end of that, the first question that I was, because we are slightly running out of time here. But somebody was asking how this has been playing out in the states and in terms of legislation and attempts, and that is super helpful. Kyle or Monica, please let me know if we have time for other questions or if we should wrap it up.
We should. Unfortunately, we don't. So if you guys have any sort of last closing remarks, feel free to make those now, and then I will let the audience know how to join the next session.
Well, I guess I would just like to say thank you very much to Laura and Hayley for participating and sharing their perspectives. I'm sorry we didn't get a chance for more questions. If there are case-specific questions, or if you have a case involving one of these issues, please reach out to us directly for ac@nacdl.org. And the Electronic Frontier Foundation is a fantastic resource on advocacy and legislative efforts. And I thank you so much, Hayley, for joining us.
Thanks for having me.
Thank you, guys.
Thank you to Mike and our panelists for that presentation. And I think, as someone had noted, we do have a lot of the information shared in the materials, and we'll also add subsequent materials as well. So all conference registrants do have access to that conference materials page. And we did share our panelists' contact information. Definitely feel free to follow up with any additional information or questions. So to join the next panel, we'll get started right at 2:30 Eastern Standard Time. And so go back to the conference webpage and click on the join link there. We'll be talking with folks and advocates from Oregon and discussing their sort of drug decriminalization efforts that have been going on underway. So thank you again for our panelists and for our audience. We hope to see you at 2:30.